Thank you, Your Honor. I call Crystal DeRue. Ms. DeRue, was Mr. Coleman present at Jackson's birth?
No.
And where was he born?
He was born in Cypress at Memorial Hermann.
And do you know why Mr. Coleman wasn't present?
He chose not to be.
And was your pregnancy and labor without incident?
No. He's your relevance judge and goes behind the order, res judicata.
I don't see how this is relevant, so sustain.
Is Jackson your first child?
Yes.
And did you and Mr. Coleman reside together after the order was entered?
No.
And can you describe your bond with Jackson before he was withheld from you in July of 2023?
Yes. Jackson was my personal piece of perfection. When I would leave him, because I do work, when I would leave him with Mr. Coleman and go to work and I would come back and pick him up, his face would just light up to see me. Like, they could be feeding him, changing him, getting him ready. He's going to stop what he's doing and he's going to run to his mother.
And how has the separation from Jackson affected you emotionally?
It's caused me anxiety, lack of sleep, health issues, more than a lot of anxiety from being separated from my son.
And you heard Mr. Coleman talk about the events of July 27th. And was that the last time you saw Jackson?
That was the last time. I had him in my custody before Mr. Coleman started withholding him from him. Yes.
So let's kind of go back to the agreement. You were working at the time, correct?
Correct.
And where were you working at that point?
I was working, when we had the court agreement, I was working at the Harris County Jail as a nurse.
And what were your hours?
12-hour days, 5:30 a.m. to 6 p.m.
And are you currently working that same type of shift work?
At the moment, no.
What is your status right now, employment-wise?
At the moment, I am unemployed. I'm a stay-at-home mom.
And after you realized that Mr. Coleman was not exchanging Jackson with you, did you try to seek help from the police?
Multiple occasions, I called the police at every encounter where he would not basically give me my child. I would call them for one civil standby because he had claimed that I assaulted him, which was a lie, on multiple occasions. So yes, I did call the police.
And obviously those attempts were not successful, correct?
Correct. I'm sorry.
Objection leading.
Sustain.
Did you ever go to Mr. Coleman's house to obtain Jackson?
Yes, this past Monday, I was advised by my attorney to attempt to exercise my right with my son.
And you weren't able to do that?
No, when I got to the house that is listed or that we have on the court order as his residence, I texted him around 12 in the afternoon, let him know that I was advised by my counsel to attempt to get my son. He responded after the time. Well, no, he responded at 6 o'clock, and basically his exact words were, "Your lawyer stated in front of the judge, in front of my lawyer, and in front of me that you can't come to my house." I then informed him that I was already there and that he doesn't live there anymore. So then he informed me that he filed a change of address at the courts, and then I responded. I asked about my son.
In Mr. Coleman's pleadings, he's alleged that you've abandoned Jackson. Did you abandon your son?
No, ma'am.
And if you wanted to abandon Jackson, would you have endured all that you've endured in the past year and a half to try to be reunited with him?
Objection not.
Were you surprised to find out that Mr. Coleman had moved and you didn't know?
No, I expect him to do that. That's what he did with his daughter. He up and left California and moved to Texas, so the mother wouldn't have access to her.
And you know this from personal knowledge?
Yes, I was with him during this time. We dated. We dated when the mother of his daughter took his daughter, and then when he got her back, he took his daughter. She left.
Non-responsive.
Sustain.
Do you believe that Mr. Coleman is attempting to do to you what he did to the mother of his other child?
Speculation.
Don't worry.
Do you believe that?
Yes.
And so far, has Mr. Coleman been successful?
Yes.
And the agreement that you currently have with Mr. Coleman, are you the parent who has the exclusive right to set up Jackson's primary residence?
Yes.
And are you all joint managing conservators?
Yes.
And now that your work schedule has changed, you're wanting the court to modify the order, correct?
Yes.
And what other circumstances have materially changed in your life?
Well, I have another child. Jackson has a little sister that he has not met yet.
Are you afraid that Mr. Coleman will harass and threaten you?
Yes.
So on a couple of the charges that Mr. Coleman had placed against you, were those dismissed?
I went to trial. I was acquitted by jury for one of them, and then the other two were dismissed, yes.
Can you tell the court what happened on July 27th, 2023, in your words?
So Mr. Coleman had been playing the game of, I'm not coming to get my son, and I'm coming to get my son. So on this particular day, on 26th, he informed me that I would need to find childcare, that he would not be coming to get his son. On the 27th of July, he shows up at my residence after I've called off work.
Non-responsive narrative.
The world. Go ahead.
He showed up at my residence unannounced. And so I walked outside to see him there, and I was surprised. I asked him, what is he doing there? That he already told me that he wasn't coming to get Jackson. And he basically mocked me. He mocked me, antagonized me, refused to put the Jackson's car seat in the car. When I came upstairs to get Jackson, I specifically handed Jackson to him, not in the passenger side of his vehicle. He set Jackson on the passenger side of his vehicle. Anyways, we had words back and forth about why he was there. And he basically called the police on me. I had called the police first and asked them to come escort him off of my property. And by the time he had drove off, when the police basically came back with the police that I had called and said that I assaulted him.
Were there any marks on Mr. Coleman's body from the assault?
No.
So you had originally contacted the police first, correct?
That's correct.
And that day is when he left with Jackson, correct?
Right.
And have you made numerous attempts through App Close to try to get possession of Jackson?
Absolutely.
Your Honor, I would like for my paralegal to share her screen and introduce the App Close evidence. It's up to...
I will look away. You can use your screen share, prove it up.
Thank you.
Unless there's no objection.
Yeah. Miss Daru, can you see the screen?
Yes.
And can you tell me what this is that you're looking at?
That is a record of a complete conversation between me and Mr. Coleman from App Close.
And is this the, can you scroll down a little bit and just scroll to the document? Does this document appear to be in the proper format, the way you're accustomed to seeing it when you pull App Close up? And
yes.
There's been substantially no changes to the document?
None at all. Correct.
And is this is an accurate depiction of the messages between you and Mr. Coleman, correct?
Correct.
And this is how you all are ordered to communicate in your agreement, correct?
Correct.
I would like to enter petitioners to, Your Honor.
Any objection?
I kind of have a partial objection. Pages 1 through 14, 1 through 16, the pages of the messages I have no objection to. However, there are attachments that are at the end of these messages. I believe it's pages 16 through 41 that contain hearsay that has not been redacted.
For 16 through 41 attachments to, like, just the document, or are they attachments on the App Close?
There are attachments on the App Close that were sent through the message, but they contain hearsay that's not been redacted.
In the response?
Yes, Your Honor. None of those messages that contain hearsay are being used for the fact of the matter being presented. These are things to be presented just for state of mind.
If I may, Judge.
He too admitted. And this is true, correct?
Yes, Your Honor. This is good.
Go ahead.
Also, if we could take judicial notice of P1, which is the agreement, we hadn't stipulated to it, but I don't think there's any objection. So I would also like to enter our P1, which is the prior order of the court.
Any objection to one?
No objection to P1.
One.
Thank you. Miss Daru, there were several messages in this app close, which is represented as P2, where you would ask for Jackson and Mr. Coleman would mock you. Is that correct?
Yes.
Like, I'm looking at page 11, and you say on August 17th of 2023, are you willing to meet to exchange our son at 6:15? Is that correct?
Yes.
And then a moment later, Mr. Coleman does what appears to be a cut and paste and just says the exact same thing right back to you, correct?
Yes, he mocks me, yes.
And approximately how many times throughout this app close document did you ask for Jackson and he mocked you?
I have not counted, but a lot.
And isn't it true that when we did go through and count the number of times you asked to see Jackson, it was approximately 40, correct?
Correct.
Is it your position that the main reason why Mr. Coleman has withheld and alienated you from your son is because you started dating another man?
Correct.
And is that pretty much a consistent theme throughout the messages that he sent you in this app close document?
Yes.
I'd also like to pull up Petitioner's Exhibit 4, Your Honor, if I could share my screen again.
Oh boy.
Thank you. Can you see the screen, Mr. Rue?
Yes.
And we'll just scroll down. And if you could identify these communications.
Yes, these are text messages between me and Mr. Coleman.
And approximately what time or basically what days, time frame? Can you give me a time frame?
This was last year, July.
And is the number 510-472-1234, is that your number or his number?
That is Mr. Coleman's number.
Okay. And then you see messages between only you and Mr. Coleman as my paralegal scrolls?
Yes.
No other third-party messages are here, correct?
None.
I would like to enter Petitioner's 4.
No objection.
Or admitted.
So, is it in these messages, and correct me if I'm wrong, whether you learn that Mr. Coleman has either been listening to you somehow or...
Yes. He used to tell me that all the time, that he had my phone tapped.
Okay. And in these messages, are you asking to see Jackson?
In these messages, no. These messages were a time when he had came and got Jackson, and he was calling my phone, telling me to answer. We had an incident where I went to go pick up my son, and Mr. Coleman
Non-responsive.
Sustained.
So was there an incident related to these text messages?
Yes.
Okay. And what was that? Was that also an incident related to you trying to pick up Jackson?
Yeah, this is the incident was relating to me picking up Jackson and him dropping off Jackson. These messages were a part of the game that he liked to play, where he's coming to get him and he's not coming to get him.
Okay. And I'd also like to enter Petitioner 7, Your Honor, if we could pull that up.
Judge, I do object to Petitioner 7 as hearsay. It's not...
And she has a heard 7.
Understood, Judge.
Ms. Coleman, Mr. Rue, can you identify this document, please?
Yes, this was a letter sent to me by Texas Department of Family and Protective Services.
Okay. And was this related to a situation where Mr. Coleman said that you were unfit and contacted CPS?
Yes.
And has this document, does this document appear to be in the same format as when you originally received it from CPS?
Yes.
And there's been no alterations whatsoever on it?
No.
I would like to offer Petitioner 7.
Judge, I object to Petitioner 7 as hearsay has not been properly authenticated by custodian of records.
Your Honor, we are only attempting to show that the state of mind that my client had as it related to this not being an actual CPS situation where it was actually ruled out. And that also that there was no physical abuse, but we're not offering it for that exact thing.
Sustained. hearsay.
Your Honor, I would also like to offer another document that's a part of the court record, which is 8. I don't know if you have an objection to that, Courtney. It's the petition for the writ of habeas.
Yeah, and to save us time, I'll stipulate to petitioners 8 through 13.
All right, 8 through 13 admitted without objection.
Ms. Coleman, how many times have Mr. Rue, I'm so sorry, I apologize. Mr. Rue, how many times have you attempted to get intervention from the court to gain access to Jackson?
This would be the 3rd time.
And what was the main issue when it came to the petition for habeas corpus, and why you were unable to obtain and get the court's intervention then?
Well, it was one, the lawyer I had, representation, and then 2, it was the way the court order was written. For the habeas corpus, I was denied my access because during the times that the court is in session, Mr. Coleman does have possessory rights.
And that's why we filed this motion to modify, so that we can have an opportunity to have the court make that change to the prior agreement, correct?
Correct.
Is it your position here that Mr. Coleman will continue to alienate you from Jackson if the court does not intervene?
Absolutely.
And are you asking the court here today for some makeup time that is continuous and uninterrupted so that you can reestablish your bond with Jackson?
Yes, it's very much needed.
And you heard the testimony of Mr. Coleman where he stated that he had no empathy to you. You heard that, correct?
Yes, ma'am.
Do you believe that it's possible for Mr. Coleman to teach Jackson empathy?
No.
Do you know why Mr. Coleman was threatening and harassing you and making false allegations?
At the time, he wanted to pursue a romantic relationship with me again, in which I told him no.
How did it make you feel when you found out that Jackson had not been to a pediatrician since you last took him?
I expected it from Mr. Coleman. He doesn't believe in the American health care. He tells me all the time, well, he used to tell me all the time that my little nursing degree wasn't nothing. So he doesn't believe in...
Objection, non-responsive.
Sustained.
So are you concerned moving forward as Jackson develops and grows? Or if Mr. Coleman is left to make the decisions about him medically, are you concerned that Jackson may not get the medical care?
Absolutely.
And have you recently gone to Jackson's pediatrician to check to see if he'd been immunized or anything?
Yes.
And the result was?
He had not seen the doctor or his dentist. That Mr. Coleman is very, very aware of who his dentist is and who his doctor is, because the last time that doctor's appointment...
Are you concerned that Jackson is being left with an underage person?
No, his sister is legally, she's 17.
Okay.
He'll be 18 in a matter of days.
So what are your safety concerns currently for Jackson with him being primarily in Mr. Coleman's custody for the last year and a half?
One is that he doesn't have his bond with his mother is stressed, which is me. And 2, the mind state of his father. That is my main concern. I don't want him to pass the lack of empathy to our son.
So considering all that has transpired, how are you going to be able to move forward in co-parenting with Mr. Coleman? And how are you going to facilitate a healthy relationship with Mr. Coleman and Jackson?
I still want Mr. Coleman to be active in his son's life. I am not trying to hinder nor take away their bond. I love it. It's a beautiful thing. At one point in time, he refused to see his son. So I'm happy that they have one. I want the courts to put something in place to where I don't have to be alienated from my son again. I don't have any intentions on coming between Mr. Coleman's bond with his son or his time.
Are you asking the court at this point to either do supervised visits, or in the alternative, at least do supervised exchanges at a police station or a fire station or something where we can establish a baseline?
Yes.
And have you in the past asked Mr. Coleman to meet you at the Spring ISD police station?
Yes.
And he refused to do that?
Yes. I recently asked this past Tuesday and Wednesday, and obviously he called the police on me.
How did you feel about Mr. Coleman saying that he puts a firm grip on Jackson's shoulder to discipline him?
We've had talks about his methods of discipline also. I've tried to explain to him that positive reassurance and positive enforcement was the best way to go. But Mr. Coleman has his own ways of doing things.
And did that raise any concerns for Jackson's emotional well-being if Mr. Coleman is using corporal punishment?
Absolutely.
That's a witness, Your Honor.
Questions of the witness?
Yes, Judge. Thank you. Do you think that Mr. Coleman is a good dad?
No. Being that what he's done to me.
Objection non-responsive after no.
Sustained.
In the last year and a half, have you observed him with Jackson?
I haven't seen him nor my son.
In 2021, when this order was entered, was Mr. Coleman a good dad?
Yes.
And you haven't observed Mr. Coleman with Jackson since then, or in the last year and a half, correct?
He's been purposely keeping my son away from me.
Non-responsive.
Sustained.
I'll rephrase. In the last year and a half, you testified that you haven't seen Mr. Coleman with Jackson, correct?
And I testified that I have not seen my son. Mr. Coleman is he's not that important to me, but no, I have not seen any one of them.
I'll clarify. Have you seen in the last year and a half Mr. Coleman interacting with Jackson?
No.
So you wouldn't know if he's a good dad currently or not, would you?
That's why we're here, Ms. Holliday.
You're non-responsive.
Sustained.
In 2021, you testified that Mr. Coleman was a good dad, right?
No.
It wasn't your testimony just now that in 2021, Mr. Coleman was a good dad?
You asked me in 2021 if I testified that he was a good dad. You need to rephrase your question, Ms. Holliday.
I'll rephrase. I apologize. Your testimony was that in 2021, Mr. Coleman was a good dad, correct?
You asked me if I would say he was a good dad in 2021.
I'll move on.
Hey.
You wouldn't put Jackson in an unsafe situation, would you?
Absolutely not.
And when this order was entered, you agreed that Mr. Coleman would have Jackson every day of the week, correct?
We would both have Jackson every day of the week.
Yeah. And what was the possession schedule?
He would have Jackson while I was at work. And then when I got off work, I would pick up my son. That was the only reason why the court order was made that way, is because I worked.
And is Jackson safe with Mr. Coleman?
That is for the courts to determine.
Objection, non-responsive.
Sustained.
You wouldn't know if Jackson is safe with Mr. Coleman today, would you?
No.
He was today in 2021 with Mr. Coleman, correct?
I think you're trying to lead me somewhere that...
Non-responsive.
Sustained.
In 2021, when you entered this agreed order with Mr. Coleman, was Jackson safe with Mr. Coleman?
Okay.
Objection asked and answered.
Sustained.
You haven't filed for a modification before now, have you?
No.
And you testified that your petitions for habeas corpus and motions for enforcement have all been denied, correct?
I never filed for a motion for enforcement yet, only the habeas.
I'll represent to you that motion for enforcement and contempt is one document. Would you agree with that?
Objection.
I'm not a lawyer. I would not agree.
Yeah, objection on that question.
Okay, what's your objection?
With relevance.
You testified that you've filed petitions for habeas corpus before and that you've filed other things with the court before, correct?
Not correct.
What have you filed with the court in this case before?
2 habeas corpuses, and recently it was the motion to enforce, and now the motion to change the court order.
Okay.
And the habeas corpuses and the motion for enforcement have been denied, correct?
Yeah, correct.
To your knowledge, is Jackson currently being well taken care of?
I don't have any knowledge, no.
Have you asked Mr. Coleman if Jackson is being cared for?
I've asked to see my son multiple times in which he's denied.
Have you asked about Jackson's well-being?
No.
Why not?
Mr. Coleman informed me that when I did ask to see my son at least, and was pleading with him to see my son, he did inform me right before we went in for the habeas corpus that my son was very well taken care of and he would see me in court.
So you haven't asked specifically whether Jackson is being fed, clothed, or bathed, or housed. Is that correct?
I don't have that worry with Mr. Coleman.
So you trust Mr. Coleman to take good care of Jackson, right?
I trust Mr. Coleman to be a father to his son and to basic needs, yes.
Where do you currently work?
It's on the record that I'm currently unemployed. I'm a stay-at-home mom.
Thank you for reading. When did you cease working full-time?
June 18th, 2023.
And did you stop working because you were fired or resigned?
No. Objection, speculation.
I'm asking, Joel.
They know. You said no. Next question.
If the court awarded you primary conservatorship today, where do you currently reside? How long have you lived there?
For a 2 years plus.
And who else currently resides there with you?
Jackson, and this is his address, and my daughter.
And non-responsive. My question is, who currently resides there with you?
She said Jackson. She said Jackson and her daughter.
In the last year and a half, have you participated in making decisions for Jackson's medical care?
Absolutely.
How?
Well, his insurance goes through me, and since my situation has changed, I've had to change his doctors and his dentist.
Have you provided Mr. Coleman with a copy of the insurance card?
Yes, I did that as soon as once we got our court order. That was the first thing I did as soon as we got out of court, via text message.
When you say when you got out of court, do you mean in 2021?
Yes.
Has the insurance changed since then?
And it changed this year in July of 2024. It changed this year.
And you haven't provided Mr. Coleman with a copy of the new insurance, have you?
No.
In the last year and a half, have you participated in any doctor's appointments for Jackson?
I haven't had Jackson in the last year and a half.
Have you asked
Been to the
doctor's appointments for Jackson?
I'm sorry, repeat the question.
Have you asked to be included in any doctor's appointments for Jackson?
Well, per your client's statement, he had not seen the doctor.
Non-responsive.
Sustain.
My question is a yes or no answer. In the last year and a half, have you asked to participate in any doctor's appointments for Jackson?
No.
So you'd agree with me that for the last year and a half, Mr. Coleman has been the sole decision maker regarding medical procedures?
I would disagree.
Isn't it true that you were arrested in July of 2023 because you struck Mr. Coleman in the face?
That would be a lie. It is not true. I was arrested for that reason, but the outcome, he lied. I did not hit him.
Was Mr. Coleman arrested on that day?
No.
Only you were arrested, correct?
Yes.
And in fact, a magistrate's order for emergency protection was entered against you. Isn't that true?
Absolutely. Correct.
At this time, Judge, I'd like to pull up what has been marked as Petitioner's Exhibit 3, which I believe has not been into evidence yet.
An objection to P3.
Petitioners to read. 1 second.
And it may be faster for opposing counsel to pull it up if that's all right.
Yeah, I have a physical copy of it here.
I do too.
I'm not trying to enter. So, I mean, if you're trying to enter it, you're going to have to do that.
I mean, do you have any objection as your exhibit?
Yes, I do actually have an objection because now that I'm looking at it, there's some squiggly and some words on the side that I can't read. Stuff has been marked out, and I guess that's an issue. I can't read it.
I'll just move on. In Mr. Rue, isn't it true that the magistrate's order for emergency protective order remained in effect for 61 days past the date of issuance?
It's year 61. I'm not sure.
Okay. And would you agree with me that 61 days after July 28th was late September?
Yes.
And would you agree with me that the emergency protective order prevailed over any existing possession orders, correct?
Incorrect.
You disagree with me?
Yes.
If you happen to have that in front of you, I'd ask you to take a look at it. Do you happen to have P3 in front of you, ma'am? As of August 3rd of 2023, the protective order was still in place, correct?
Correct.
And at that time, the order prohibited you from going to Mr. Coleman's residence. Is that correct?
Correct.
I would like to pull up what has been pre-admitted as Petitioner's Exhibit 2, the messages.
Okay.
And if the court will bear with me for just one moment. I'm going to share my screen. Astria, please let me know when you see the document.
I can see it.
Okay. And you just see the what's been marked as P2, the app close exhibits. Is that correct?
Yes.
I want us to look at page 9 of the app closed document. Do you see page 9 on your screen?
Yes.
And we agreed that as of August 3rd, the protective order was in place, correct?
Yes.
Your next message is 5 days later on October 7th. Is that correct?
I cannot see.
You need me to zoom in more?
Yes. I can see it.
Do you agree with me that your next message was on August 7th, 5 days later?
Correct.
And the protective order was still in place at this point, correct?
Correct.
You're asking to see Jackson, is that right?
To exchange Jackson. Correct.
Because you were prohibited from going to Mr. Coleman's residence, correct?
Correct. I was instructed by the judge presiding over that case.
Yes.
Sustained.
And then I'm going to scroll through here, but would you agree with me that then you messaged Mr. Coleman nearly daily until mid-September, right?
Absolutely.
And during this time, the protective order prohibited you from going to Mr. Coleman's residence. Is that right?
Correct.
Scroll through here. And then you didn't message Mr. Coleman again to see Jackson until February 12th, 2024. Isn't that true?
The last call that I made to Mr. Coleman,
Objection. My question was a message.
I believe that I should explain why, because it was a life-altering experience.
Objection. Non-responsive.
Sustained.
You didn't ask to see Jackson again until February 12th of 2024. Isn't that true?
I was out the country. Correct.
So isn't it true that between September of 2023 and February of 2024, you made no efforts or attempts to see your son?
Incorrect.
Show me a message between September 2023 and February 2024 where you've asked to see Jackson. I'll keep scrolling. Did you see any messages?
Did not.
You didn't go to Mr. Coleman's residence to pick up Jackson either during this time, did you?
I'm sorry, during what time?
Between September of 2023 and February of 2024.
No, I did not. September 23. September, October. No, I did not.
Do you recall testifying that you were scared to go to Mr. Coleman's residence?
Absolutely.
Did you ever ask for a civil standby?
Yes, I did.
When?
All of the times that I had been going to his house after the first,
Non-responsive.
Oh, you asked her when, and she said all the times I've been going to his house, and then was going to say,
that I have incidents reports for every time that they was on.
okay, now it's not a response.
Between September 2023 and February of 2024, did you ever call for a civil standby to go pick up your son?
Yes.
What date specifically?
I do not recall.
Do you have anything to present today to give us a date?
I would need to talk to my attorney about that.
Isn't it true that you've been charged for violation of the protective order?
At one point in time, yes, I was charged.
And did you make a deal with the ADA to avoid a conviction on that charge?
No, I didn't make a deal. They informed me.
Objection, non-responsive.
After no, sustained.
Isn't it true that you made a deal with the ADA to avoid conviction on your assault case involving Mr. Coleman?
No.
Judge, I am going to show the witness a document that has not been marked as an exhibit yet.
Dang. Are you doing so for impeachment purposes?
Yes, Judge.
Right, you can use the screen share.
Again, I ask the court to please bear with me. Mr. Do you see my screen share?
Yes, I do.
And what is the header on this document?
It is the criminal case number that I was in the state of Texas versus me for assault of a family member.
And this is a motion to dismiss, correct?
Yes.
And this is signed by the ADA on your assault of a family member case, correct?
Yes.
And it says that, I'll zoom out. The state respectfully requests the court to dismiss the above entitled and numbered criminal action for the following reasons. Is that correct?
Yes.
And what reason is checked off?
It said pretrial diversion program completed. Other admission writing.
Sorry. Sustained.
And this is a deal that you made with the ADA, correct?
Yes.
So you lied to the court when you said that you didn't make a deal.
So they call it a deal, and I wouldn't say I lied.
Objection, non-responsive.
Everything except I wouldn't say I lied.
Did you lie to the court when you said you were acquitted by a jury?
No.
What does a pretrial diversion program include?
I don't know what pretrial diversion programs include, but I was instructed by my attorney at the time to do a anger management class in community service.
And what did you learn in your anger management class?
Positive ways to redirect your anger.
How long did that program last?
4 hours.
To your knowledge, has Mr. Coleman ever been instructed to take an anger management course?
Not that I know of.
Isn't it true that you've had several criminal charges?
Objection, relevance.
Judge, it goes to the best interest of the child.
Sustained.
Isn't it true that on or about May 19th, 2009, you were arrested at the Madrid airport in Spain?
I'm sorry, relevance. That was before the child was here.
You can't object.
Objection, Your Honor. As to time frame, that's 2009, as my client just stated.
Time frame isn't the objection.
It's prior to the agreement for this particular child, and it's outside of the scope of the time frame.
So would that be relevance?
Yes, it's relevance.
Sustained.
Mr. Rue, have you ever served time in prison or jail?
Yes, I have.
Why should Mr. Coleman trust you with Jackson when you haven't been involved in Jackson's life for over a year and a half?
Mr. Coleman is the reason why I haven't been involved in my son's life in over a year and a half. We are here today because of the actions.
You can wait for me to ask a question.
Sustained.
You testified that you were concerned about Jackson's medical care. Is that correct?
I'm concerned about my son in general, yes.
Have you specifically asked in the last year and a half about Jackson's medical care?
I shouldn't have to ask.
I'm sorry, Judge, was there an objection?
Yes, asked and answered.
And you testified that you've tried 3 times to get court intervention to see Jackson. Is that correct?
Correct.
And that's only 3 times in the last year and a half. Is that correct?
Correct.
So you haven't tried on a near daily basis to see Jackson. Isn't that true?
No, incorrect.
We testified and we looked at documents to show you didn't ask to see Jackson between September and February. Is that correct?
Ms. Holliday, the last time I spoke to Mr. Coleman was October 13th, so I'm going to say incorrect. And I'm incorrect.
You've used the word withholding a lot throughout today's hearing. When has Mr. Coleman withheld Jackson from you?
Every day, every time that I was supposed to have access since July 27th of last year. He's been withholding my son.
And you testified you haven't gone to his residence to pick up Jackson. Isn't that true?
Can I get a time frame? The question isn't specific because I would have to say something.
In the last year and a half, we've established that you have not gone to Mr. Coleman's residence to pick up Jackson.
That would be incorrect. That would be incorrect. I have. In the last year and a half, I have.
We looked at messages between September and February, September of 2023 to February 24, that you did not ask to see Jackson, right?
Incorrect. There's a call that was made October 13th.
Objection, non-responsive.
For incorrect, sustained. But you have asked that numerous times.
Understood, Judge. I'll pass the witness.
Anything else of this witness?
Yes, thank you, Your Honor. I would like to pull up, Your Honor, our incident and event reports concerning the standbys.
Just pull it up and prove it up.
Yes, petitioners 15, please. Oh, wait a minute. I don't think that's the one for, hold on, child custody. That's not the standby. My bad. I'm sorry. I need 18. I'm sorry. Petitioner's 18. Mr. Rue, can you tell me what this is a copy of?
This looks like incident report.
And is this paper and document in the same order that you recall seeing it in originally without any changes?
Yes.
And did you make a call for assistance, and this was the report that was created as a result of that call?
Yes.
And was this an attempt you made at Mr. Coleman's home to retrieve Jackson?
Yes.
And you contacted which police dispatch? Do you recall?
I believe it was either the sheriff's office or the constable.
And to your knowledge, no changes have been made to this document?
No.
I would like to enter petitioners 18.
Judge, we object to hearsay and that this document has not been authenticated by a custodian of records.
Like a certified copy?
No, Your Honor, this is not a certified.
Sustain us in hearsay.
Miss Coleman, what day did you go to try to retrieve your son and end up having to call the police?
It was in September. I do not recall the exact date.
Would it be around August the 7th of 2023?
Meeting.
Sustain.
And did you also go in September? Did you go?
Meeting.
Sustained.
Can you tell the court the days that you went to Mr. Coleman's house to retrieve Jackson?
I do not recall all of the days. The most recent day was Monday.
Objection, non-responsive.
Wow.
And given the times that Mr. Coleman has falsely accused you, have you learned to take his threats seriously?
Yes.
And did he threaten you if you came to his home?
Yes, in the past he has threatened me not to come to his house.
Are you excited about introducing Jackson to his little sister?
Absolutely.
And there was some, I would also like to pull up what's already pre-marked as Petitioner's 9, which is the acquittal from your jury. Can we have that on the screen, please? Because I want to clarify that. So while my paralegal's pulling that up, were there 2 criminal cases that are distinctive in this Mr. Room?
Yes.
Okay. So what you're looking at right now, which has already been admitted into evidence as Petitioner's 9, what is this a document of?
That is a document of my acquittal by jury.
So which case was this related to? Which day and which incident was this case related to?
This was related to the end of September incident.
And then the other case that Ms. Holliday was explaining where you did a pretrial diversion, which case was that related to?
That the pretrial diversion was for the violation of the bond order.
And on the violation of the bond, or was it the protective order, violation of the protective order?
Yes.
Did you violate the protective order?
No.
Did Mr. Coleman lie about you violating the protective order?
Yes.
Oh, wait. I thought I heard an objection.
Yes, Judge, I objected to call for speculation. Most she's already answered.
All right. She already answered. Overall, continue.
Why do you think he would lie about that?
Objection calls for speculation.
Sustained.
Do you know why he lied?
I believe that it was his intent.
Objection, non-responsive.
Sustained.
You said that you've been at your current address for about 2+ years. Is that correct?
Correct.
So when Jackson comes to your home, that'll be the same home that he's familiar with?
Absolutely.
And does Jackson still have a room in that home?
Absolutely.
And are his things still set up the way they were when he was last there?
Yes, they are.
There was some conversation earlier about Jackson and him being almost being potty trained back in July of 2023. Was he almost potty trained back then?
Yes.
And were you responsible for doing most of that potty training?
We shared the responsibility.
And did it surprise you to hear now that Jackson is not fully potty trained?
Absolutely.
Objection misstates testimony.
Sustained.
Did you hear the testimony that Mr. Coleman said that Jackson still sometimes has accidents at night?
Yes, I did.
When you made your previous attempts to get intervention from the court in this matter, were all of those attempts in good faith?
Yes, they were.
And were they solely and merely to reunite you with your son?
Yes, they were.
And do you love your son?
Yes, I do.
Can you explain to the court why there was a time frame that you did stop asking for him?
Yes. October 13th, it was a Friday, October 13th, 2023, I received a call that my father had died in Peru. So I received that call at 7:00 in the morning. The next person I called was Mr. Coleman. That call was made at 7-something in the morning, right after I received the phone call. And I informed him that my father had passed, that I was tired of going back and forth with him and dealing with this nonsense. So that he needs to kiss my son for me. I have to leave the country and figure out how I'm going to get my father's body from Peru to Nigeria and give my father proper burial.
And were you able to give your father a proper burial?
I was.
And is that the time frame that Miss Holliday was discussing it? So were you in different countries during that time?
I was in Nigeria. I didn't get back to January 28th, 2024.
My condolences for your loss.
Thank you.
So are you asking the court for you to be able to see Jackson today?
I would love that more than anything.
And are you asking that the court order that you be able to do that in the safest way possible that the court can think of?
Yes.
And in an ideal world for you, what would the next month look like regarding you and Jackson's time together?
Well, one, I would like to spend time with my son and bond. He hasn't seen his family members. He hasn't met his little sister. He hasn't seen his cousins. Everyone's waiting on his arrival, and it's the holidays. So I have gifts, birthday gifts from the last 2 years, still accumulated in his closet that he has not had a chance to open. I have new clothes that I have to sort through when he gets home to see what he can fit, what he can't. He has new clothes that's been bought. We have a whole life to get back together and bond.
And how old is his little sister now?
She's 2 months.
And do you anticipate him being a good big brother?
Absolutely.
Are all of the criminal matters that have evolved over the past year and a half with you and Mr. Coleman resolved?
Yes.
And do you have any plans on putting Jackson in daycare?
Jackson has been enrolled in daycare for over a year. I recently ended it on his birthday because I want to re-enroll him somewhere else.
And he has not gone to that where he's been enrolled?
We're to today.
Do you believe that Mr. Coleman's visitations as a result of all of this should be supervised?
Absolutely.
As witness.
Anything of this witness?
Briefly, Judge, I believe I just have a few minutes. Mr. Rue, you haven't presented anything to show any safety concerns for Jackson while he's in Mr. Coleman's care. Is that correct?
Incorrect.
You've shown some documents today showing that Jackson's unsafe with Mr. Coleman. Is that what you're saying?
The fact that we're here today, yes.
Non-responsive.
Everything except yes.
You said that you've enrolled Jackson in daycare for the last year?
Yes.
You've enrolled him in daycare for the last year, but you haven't seen him in a year and a half. Is that correct?
Correct.
You've been paying for daycare, but you haven't been taking Jackson to. Is that correct?
Correct.
Nothing further, Judge.
Anything else, Ms. Broussard? 10 seconds.
I was just getting ready to ask my paralegal. No, thank you, Your Honor. I won't belabor in 10 seconds.
Ms. Holiday, anything else?
No, does the court want a closing statement?
I don't think I need one.
Understood. Then nothing further, Judge.
I don't know what transpired on that day a year and a half ago. I was not there. But what did or did not happen on that day doesn't mean we lose out on a year and a half of our young child's life. I to choose my words carefully. We don't get to cut the other parent out of the child's life. We don't get to cut the other parent out of the child's life and replace them with a new significant other. I understand that new significant other may want to be the parent, but they are not, in fact, the parent. And I think that's very hurtful. Some of the rather flippant comments regarding the new significant other. Well, I guess not new, because somehow they've been together 16 years. But he has a child with Ms. Duru within that time frame. I'm not sure how that works, but put your hand out. And then I also heard, not only did somebody state that they lacked empathy for the other parent, but they laughed about lacking empathy for the other parent. No matter what has transpired between the two of y'all are both the parents of this child. And to laugh about something so serious and hurtful is quite profound. On the flip side of that, I understand you had a death in the family, but you don't just get to ignore your obligation to your child for 4 months or 3 months. And I still don't understand what has happened every single day at 6:15 or 6:45, whatever the time to pick up is. I understand that there was a magistrate's protective order, but that has long expired. So at minimum, every single day at, I believe, 6:15, and maybe you're incorrect. You can look at the order. Yeah, at 6:15, mother should have been able to see the child. I don't know whether or not mother went to the house every single day at 6:15. I also don't know whether if she did go to the house, if Mr. Coleman would give her the child. Based on his comments regarding the mother, I don't think he would. I think both of my comments have been rather harsh for both of y'all. And I'm not trying to be mean, but y'all have a 3-year-old. You're going to be in each other's lives for a very long time. It would kill me to not see my kid for a year and a half. It kills me to not see my kids when I'm at work. I understand that I have to provide for them and I have to come to work, but it still kills me that I don't get to be there with them. I can't imagine what a year and a half is. I don't think I got a proposed requested relief from either of y'all. In fact, I know I didn't. But for the health and safety of the child, I'm not going to modify conservatorship. Conservatorship is going to remain. Y'all are still going to use app close. That's not modified. Passport provisions are not modified. Cash medical is not modified. I have no idea how much either of the parties make. So I can't order child support. No one brought up anything about how much either of the parents make. So child support's not modified. However, possession and access is not workable. So for the health and safety of the child, I am going to modify possession and access. Mr. Sard, this holiday, do you think you can work that out if I put you in a breakout room? Or do I need to render?
I think you need to render, Your Honor.
Very good. All right. As stated in this order, mother is primary because I'm not modifying conservatorship. Father will have the child is over the age of 3. Father will have an expanded standard possession order. What part of town do they live in?
I'm sorry, I didn't understand you. Say that again.
What part of town do they live
In Spring.
in? Do they both live in Spring?
I believe so, yes, Judge.
I guess pickup and drop off should be at the child's school if the child is enrolled, or daycare if the child is enrolled. If the child is not enrolled, pickup and drop off will be at Harris County Constable Precinct 4, located on Cypresswood, 6831 Cypresswood Drive, Spring, Texas, 77379.
That was 6331.
6831. That being said, this is the first weekend of the month, our first Friday of the month. Father will have superior right to possession beginning today until the 19th until he'll get his Thursday on the 12th, and then he'll get the weekend of the 19th, which is a Thursday. Oh, heard enough for both of y'all.
I'm sorry, Your Honor. I was trying to write and understand. So if you could clarify. So father has the expanded possession and he has a superior right today since this is the first week in the month.
Normally would, but because she hasn't seen her kid, he's not going to start that until next Thursday.
Okay, that's where I was confused. So today,
she is going to have superior right to possession today. So they are going to exchange the child today to mom at 5 p.m. at that Cypresswood location.
And then next Thursday, his superior right picks up.
Correct, which will be his Thursday evening possession. And then the 19th would be the third, or the 20th would be the third Friday. So that would be the 19th, whatever.
Okay, thank you for the clarity.
And Judge, will holidays be per standard possession order?
Right. All right. Entry will be December 20th. Can y'all get it done in that time?
Yes, Judge.
Yes, Your Honor.
Entry December 20th at 8 o'clock a.m. by submission.